The sound of those gunshots is a proof that it is a joyful mood here at the Rumfa Palace of Emir Sanusi Lamido Sanusi in the ancient city of Kano State. The Emir today is also holding court with some of his subjects who have come here to pay him homage. The news about the judgment given by the Court of Appeal in Abuja, ruling that the Federal High Court has no jurisdiction over chieftaincy matter, stirred a lot of joy among the people here in Kano State. To them, with this judgment, it is a proof that Emir Sanusi Lamido Sanusi remains the Emir of Kano State.
We are so much happy with this, with this decision. Though already this is what we are expecting. If the decision is based on the right facts, this is what will be the result, definitely. And we are so much happy with this, and as you can see how people are happy, how people are enjoying based on this. The judgment means that the Emir of Kano, Muhammad Sanusi II, remain the Emir of Kano.
We are so happy today, and we thank God for making Emir Sanusi victorious. Everyone is so happy with the outcome of the judgment. God has given us victory. Muhammad Sanusi II remains our Emir in Kano. I am so happy today. The victory will be celebrated together with my family when I get home.
Arise News also visited the palace of the 15th Emir of Kano, Aminu Ado Bayero, where some of his supporters had also converged while awaiting the judgment. The Emir also stepped out, waving at them, but palace officials declined comment on the outcome of the ruling of the Court of Appeal. With the dust yet to be finally settled on who retains the throne of the Kano Emirate, all eyes will now be on the State High Court to determine the matter. Ayo Adenayi, Arise News Kano.
Thank you, Ayo, for that report. Now we have Senior Advocate of Nigeria, West Idahosa, who joins me in the studio to unpack this development. Thanks so much for joining me.
Thank you for having me.
I'm so happy we have a legal expert in the building and SAN to just help us understand, help our viewers to understand, what does this mean? It seems like every couple of months there's a development coming from the courts concerning the emirship in Kano. What does this judgment really mean?
Well, first I have to commend the Court of Appeal. I mean, they've done some real yeoman's job. I mean, they've really settled plenty dust. Now, remember that when the issue of the Federal High Court came in, there were many legal experts and even non-legal experts who said, this is too much indulgence. There must be a line to rascality. You know that there is no level of involvement that the law grants you. Why are you doing this? What kind of politics can be mixed with the law to give you that type of jurisdiction? But we are in dire times. And then they went ahead and did that. So I'm glad that the Court of Appeal has reminded the Federal High Court that Emirship Tussle is strictly a chieftaincy matter. It's determined by state laws. And that is settled. And the painful thing about it was that there had been a matter which was so similar to this before. The question of Tussle versus the governor of Gongola State is something that even law students learn in the law school. That look, you can't use fundamental human rights as an excuse to invade the territory of chieftaincy. And I'm sure Justice Kolawole, probably one of the very brilliant judges of our country, put that right and squarely, and a lot of people accept that because he is one of the emerging Caesaros of his time. Now, go back to the other court judgment. The other judgment was also fair and square. It said clearly, look, the High Court, yes, you have jurisdiction, but you owe the parties a duty to promote fair hearing. And that if there was a reason for counsel to withdraw for whatever reason, either in dissatisfaction or change of mandate, you had a duty to put the parties on notice to provide themselves with another counsel or to come before the court and to conduct the case themselves. That wasn't done, and that was a breach of the right to fair hearing. And no matter how brilliant the decision was, it nullifies the entire proceedings.
In your experience, because I know that Justice Mustafa described what you're talking about, and correct me if I'm wrong, the Kano State High Court's initial proceedings as a travesty of justice due to the lack of fair hearing for Aminu Bayero. In your experience, how often does such procedural lapses occur, and how important is it for the courts to make sure that this does not happen?
Well, in those days, when we started practice as young lawyers, it was rare to have that. But as, like every other thing, as standards went down, it became a recurring decimal. But you see, I'm glad that it has reached a point where everyone is trying, to correct these errors. And significantly, this is an elementary point of law. We know that no matter how nice your decision turns out to be, if you made that fundamental error of not giving the parties equal opportunity, the right to fair hearing, then of course you've made a big mistake, which will result in the type of result that you are getting in the Court of Appeal. And there is a big difference between not availing your right to be heard, that's your business, and not being given that right. So on this occasion, the Court of Appeal has made these observations and made consequential pronouncements. And I think that what that means is the parties go back to the drawing board and get that opportunity, and then get a decision that is not only palpably legal, acceptable, because acceptability of decisions is also part of the credibility of a decision of the court.
And that brings me to public confidence in the judiciary. We had Justice Gabriel Kolawale's minority judgments emphasizing the need to return the case to the Kano State High Court for fresh adjudication.
Yeah.
How does this minority judgment influence public confidence in the judiciary? And does it complicate or enrich the legal discourse surrounding sort of a high-profile cases that we see in Nigeria?
Well, minority judgments help to enrich the legal literature. It helps also to give additional knowledge to the law. But significantly, the procedure is clear. The majority judgment is the judgment of the court. The minority judgment, in my view, is the theoretical literature improvement of the law, because it gives its own alternative reasoning. That can be the basis to go to the Supreme Court and take that and expand that and formulate grounds of appeal from that. So on the whole, sometimes it's a welcome development.
Now, you have the appeal court ordering fresh hearing in the cases involving both Bayero, both Sanusi, even though we're seeing people celebrating. What precedence does this set for future chieftaincy disputes? Because one thing we know about Nigeria is there will be disputes, especially when it comes to sort of chieftaincy issues.
Well, the first precedent is Federal High Court stay clear. That helps to narrow the congestion of confusion, all right? And then once we get them out, the next point will be dealing with the state high courts. We will ask the political actors in all of these states to dabble less into traditionalism, because this is purely politics at work. It's very clear to me that there seems to be no place for traditional prestige, because if there was, we will have to stay very far from it in the name of politics. So let me advise the politicians to appreciate the fact that our traditionalism and cultural heritage is part of what makes us who we are as a nation and who we are as tribal entities. If you destroy them, you destroy the essence of our beginning. And so that's the reason why they must play less politics with these traditions and make more use of traditional institutions in securing peace and tranquility in their states. When we were younger, the military made very good use of traditional rulers in promoting peace and tranquility. Remember, they didn't have the structures that modern political governments have. So what they simply did was to use existing traditional structures to push messages to the grassroots and to get the grassroots under control. So why don't we return there and make better use, instead of promoting litigation from one pillar to another, abusing court processes, getting multiple judgments over the same issues, same parties, and same dispute.
I was going to ask you, but I think you already answered that. We've clearly not seen the end of this. But finally, before I let you go, with such a deep traditional, legal, political matter, what would you say is your key takeaway for Nigerians about the rule of law and the preservation of our cultural heritage in the face of sort of our modern governance system?
I think the rule of law is supreme. We should let it be. Once that decision is made, if we all will abide, it brings us to a state of modern government, constitutional democracy. Secondly, traditional institutions are critical as substructures to the modern government. Before they came, many of them were sole native authorities. They ran their domains effectively and efficiently. So let them be and have a blend where there is an equilibrium between modern government and traditionalism for the good of our society and for the promotion of good governance as provided for by the Nigerian Constitution.
And we'll leave it there. Thank you so much for enlightening our guests and joining me on Newsnight. West Idahosa, a senior advocate of Nigeria.
Thank you very much.